You read and understand the English language?
Yes.
Are you presently under the influence of any drugs, medication, or alcohol?
No.
Have you ever been treated for a mental illness?
No.
Are they giving you any medication in the jail right now?
No.
How are you feeling this morning?
Confused.
I understand. I'm a little confused myself.
Why do they need a week?
Judge, the only thing I would like to have you possibly consider is that you had said you were prepared to ask Mr. Deming some questions right now. I'm a little concerned that with the lack of information that exists in this case, for him to even opine on where to go right now, based on what? The paragraph in their motion that says that he has to make a decision now because you told him there's a conflict.
I'm not going to ask him any questions. I'm just going to explain to him the choices that he's made. No different than a defendant deciding to testify or not testify at a trial. I'm not going to ask him any questions. I'm telling him what's coming. Because at some point, he is going to have to tell me what he wants me to do.
And of course, we're going to...
Oh, you already told him.
Until the time that he's fully informed as to what there is that may be a conflict, he is in no position to answer, to make an opinion as to whether...
I'm not asking his opinion. You're objecting to me talking to your client about his rights?
It depends on what you say, Judge, but I am prefacing what your comments are because I was under the impression that you were going to inquire with him as to whether or not that he finds there's a conflict.
No, I'm not.
Okay, great.
I'm not.
That's what it sounded like he said, though.
Again, so the record is crystal clear on this. I'm following this procedure pursuant to a case called Figueroa, Figueroa,
Jeez.
Sanabria, Sanabria versus State. It's a Florida Supreme Court case from 2023. It's found at 366 Southern 3rd, 1035. And this was a death penalty case as well.
He's looking at the death penalty.
I'll quote what the Florida Supreme Court quotes. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. All competent defendants have the right to control their own destinies. He's entitled to his constitutional right of assistance of counsel, and there's nothing that makes him relinquish this right. So all I'm going to do this morning is explain to Mr. Demens that at some point this is going to be his choice. I'm sure his lawyers will give him the best advice, but this is going to be his decision. And he may not agree with your advice at some point, just like a defendant may decide to testify or not testify and not follow a lawyer's advice. But I take this decision to be the same way. It's a fundamental decision. This is a client decision. This isn't a lawyer decision. So, Mr. Demens, raise your right hand for me.
All right, here we
You don't
go.
have to stand. You're okay. You can sit. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your full name.
Chanel Maurice Jim,
How old are you?
25.
How far did you go to school?
So young.
I graduated, well, I got my own GED.
You read and understand the English language?
Yes.
Are you presently under the influence of any drugs, medication, or alcohol?
No.
Have you ever been treated for a mental illness?
No.
Are they giving you any medication in the jail right now?
No.
How are you feeling this morning?
Confused.
I understand. I'm a little confused myself. Your head is clear? You're not hearing voices. You
No.
hear your lawyers. You're talking to your lawyers. You understand what's going on this morning?
Yeah.
Okay. All right, so Mr. Demens, here's the deal. You're, just like any other defendant, you're entitled to have a conflict-free lawyer or lawyers representing you. Okay, a lawyer that has your best interest in mind to the exclusion of anything else. You with me so far?
25, man.
The state has told you that one of your lawyers is currently under investigation. For what? I have no idea. But there's some ongoing criminal investigation. Okay? You with me so far?
Yes.
Okay. So, this, what your lawyers correctly pointed out yesterday, raises immediately what we call a conflict of interest. In other words, maybe at some point during this litigation or some point during the trial, my lawyer's not going to do what's the best thing for me. My lawyer's going to do what's the best thing for my lawyer. And your two interests are separate. You understand that?
Yes, sir.
Okay. So, once your lawyers have had the opportunity to investigate all this, to get you all the information they can possibly get, so they can talk to you about all this, at some point, you're going to have to make a decision about who you want your lawyers to be going forward. You with me on that?
Yes.
Okay. Even if there is a conflict, you can waive the conflict if you want and say, Judge, I understand there's a conflict, but that's okay. I like these lawyers. They're doing a great job for me. They did a great job for me in the past, and I don't want to change, lawyers this late in the game. You understand that?
Also, he can raise that at any time and at any point in time. So this isn't the final decision.
Yeah.
Or you could likewise say the opposite and say, Judge, I don't feel comfortable with this. I think there's a conflict. I don't think Miss Liberty should be my lawyer anymore. I don't think any of my lawyers should be my lawyer anymore. And I want to go get some new lawyers. And if you want to hire your own lawyers, you can go out there and hire anyone you want. And if you want me to appoint lawyers to represent you, you would have to file an application with the clerk's office. And if they find that you're financially qualified,
Gonna get Brian Steele.
to represent you.
Brian Steele and
Doug.
Doug Weinstein.
The whole point I'm trying to make with you today, sir, is that this is going to be your decision. Your decision. Your lawyers will give you their best advice, and you have some excellent lawyers, okay, about what they think you should do. But at the end of the day, you can follow their advice, or you don't have to follow their advice. It's your decision. Do you understand that?
Yeah.
Okay. Do you have any questions for me about anything that I've said so far?
Can we have a moment, John?
Sure.
Yeah, he also needs to know that he can change his mind at any point. I'm surprised the judge didn't tell him that. Like, hey, this isn't a final decision. If you gain more information and you say, hey, Judge, I'm not feeling them anymore.
All right. So, Mr. Evans, I'm pressing pause on the conversation at this point. We're going to have the second half of this conversation at some point in the future. I hope it's sooner in the
I agree,
future rather
Kel-Bell.
than later. Because the last point I want to make sure, and I'm giving you and your family and your lawyers as much notice of this as I can, your case is set for trial September the 10th. And that's not that far away. Do you understand that? Okay. Your case is going to go to trial on September the 10th. So if you change lawyers, you're going to get a group of lawyers in place that are going to have like 7 months to prepare a capital case, okay? So the longer it takes to make this decision.
I'm going to object to what the court has just said. What you're telling him is right now that he is basically having to stay with us as his attorney, because if not, then he'll get another set of lawyers that will not be prepared, and they will only have 8 months to do what
Come on,
he's
Judge.
to do, and therefore you're pushing him into the corner that he has to stay with us. I don't think that's fair what the court has said.
Over your objection, sir. That's not what I'm saying at all. I want to make sure that you understand that time is of the essence. Do you understand that?
Yes, sir.
Okay. Okay. So I'm going to put them back on the docket February the 18th at 9:30 a.m. This issue with the warrant will be resolved at this point, and whatever's going to be distributed to the parties will have long since been distributed to the parties.
We'll
You
see.
all can file whatever additional motions you think are appropriate. If there's any motion that the state wants me to hear, we're going to do that in a notice of hearing. That's by the close of business on Friday, February the 7th. Defense, if there's any motion that you want me to hear, you're going to do that in a written notice of hearing by Friday, February the 7th. If I don't have something noticed in writing by Friday, February the 7th at the close of business, I will not be hearing it on Tuesday, February the 18th. Mr. Demons' case remains set for trial September the 10th at 9 o'clock. State, anything else that I can do for you this morning?
No, Judge.
Defense, with the exception of your,
Yes.
all right, is the state coming up here too?
Yes.
Okay. Mike, this is not on the record. Dan, I think there's a microphone here. That needs to go.
All right, so there's a little off the record conversation happening here. And thank you to the Honorable Attorney Kel-Bell for being here in the chat. She says, he said he is confused. I watched part of this last trial. It appears that he is actually very bright and was constantly talking with his attorneys as things happened in court. Yeah, and I mean, him being confused is not surprising because it's very confusing, and even his defense attorneys were confused. Judge, they've had over a year to provide this information? Why should we wait until the middle of February? Just says, okay, you're right. I'll give them a week. Why do they have to wait a week? They've had it since December of 2023. Stay out of this system, man.